because he is a believer in polygamy. And as you know, the Mormon Church has not embraced polygamy since the 1890s. But he converts. Following their separation, this daughter is living with the mother and her children from a prior marriage. The father then sought a petition to seek joint legal custody of this girl, post-divorce. The trial court holds a hearing. The father testified during the hearing that, yes, I practice Mormon fundamentalist issues, the teachings of Joseph Smith and Brigham Young. He further stated that the fundamentalism includes plural marriage. He testified that he's not set a limit on the number of wives that he would like to seek. When asked if he would try to have his daughter have multiple partners, he said that he wanted to teach her about his religion, and that was something she needed to know. There was also testimony from one of the girls from the prior marriage who said at age 13 she had a conversation with this man, of course her stepfather, in which he told her that if you don't practice polygamy or you don't agree with it, that you're going to hell. Interesting to me how the women are always the ones that go to hell for not following the man's direction, but that's what he had to say. He also said to her that since I'm already living in the same house with you, this is a 13-year-old girl, and since we're already related, it would be a good idea for you and I to get married. The trial court said that while we have evidence of moral deficiency of the father, there has been no evidence of a grave threat to the child or to the children. You see, this is the analysis of religious speech versus religious conduct. And the Pennsylvania Supreme Court held that he's entitled, of course, to have his views on religion and to express them to this child. And it's interesting. Here's what the Supreme Court of Pennsylvania says. It is clear that the Commonwealth's interest in promoting compliance with a statute criminalizing bigamy is not an interest of the highest order that would supersede the interest of a parent in speaking to a child about a deeply held aspect of his or her faith. Very troubling. The dissent, of course, is chagrined that there's no finding of harm in this situation. And the dissent goes on to point out, I think very persuasively, that it is imperative to distinguish matters of free expression from matters of immoral and criminal conduct. When the father speaks to a daughter in that way, it amounts to indoctrination. And in that situation, the state has an interest in protecting the child. The last thing I will tell you about religion and speech, there's an interesting case out of Oregon, the Bolt case, in which the question arises when the parents have different views regarding circumcision of a child, what is a court to do? In this case, the father had custody of the child was 12 years old, he had religious decision-making, okay? And in the religious decision-making context, he said, I want this 12-year-old son to be circumcised. When the ex-wife found out about that, she filed a petition asking for two things. Number one, a change in custody. Number two, an order from the trial court prohibiting the circumcision. The trial court found that the husband, because he was the religious decision maker, had a fundamental right to make that decision free from the interference of the state or the interference of his ex-wife. That case went to the Oregon Supreme Court recently, who held that the decision to circumcise a male child is one that generally falls within a custodial parent's authority. It should not be interfered with. However, the court remanded it to the trial court to ask this question. Is this something that the 12-year-old child wants? And that's a troubling question, because had it been posed in a medical context, we would say, at what age is it appropriate for a child to say what medical decisions should be made for me? And when you extrapolate that into a religious context and say to the child, your parent has religious decision-making, but you have authority or at least input at age X, the question I think that would arise is at what age is that really appropriate? I think in the YFZ case, the Yearning for Zion case in Texas, the standard for removal of those children in a religious-based context is very troublesome absent clear showings of abuse, and that's a personal opinion. But I think the more interesting question in YFZ is this: what would happen in a secular divorce of members of that ranch? What would happen? Think about the configuration of what they contend is a family, and what would a secular judge do regarding custody? What would they do regarding support? And I think, interestingly, more than that, what would they do regarding visitation? Who has the right to visit? Under what circumstances? I probably didn't include this in your materials, but there's an interesting article from the New York Law Journal that talks about free speech and whether parents in intact families have more free speech than parents in families that have been disrupted. And it's kind of interesting because in an intact family, you can teach your child anything. You can teach your child racism. You can teach your child communism. You could teach your child bigamy, and the state is unconcerned. But the article poses the question, what happens to the free speech rights of a non-custodial parent? It's a little esoteric, but it's interesting because it seems to be that the majority of decisions in this country find a diminishment of your constitutional rights to both free speech and to the exercise of religion once you are labeled a non-custodial parent. It's an interesting article. If anyone finds it interesting, please let me know and I'll give you the citation. There are cases in other jurisdictions in which, in divorce settings, there are contractual provisions regarding limitations of free speech and free religion. I would suggest to you that those are something that largely should be ignored because there's something that simply cannot be enforced. Again, they have the in terrorem effect. The third topic I wanted to talk to you just a little bit about is the concept of alimony. And the question arises, I think, in today's context, and John Wilson wrote an interesting article about this in the Family Law newsletter recently, is the concept of alimony post-generational? Think about that. Is the concept of alimony post-generational? Is it contrary to the partnership theory of marriage? Is there invidious sexism inherent in the concept of alimony? To what extent should alimony be better defined? To what extent do judges and juries have too much discretion regarding the award of alimony? Believe it or not, other jurisdictions are considering alimony guidelines similar to child support guidelines. In the state of Massachusetts, a bill is pending before the legislature that would put limits on how long alimony can be paid. And it would carve out a provision that would prevent a second wife's income from being used in a consideration of paying alimony to wife number one. In Nevada, lawmakers are considering a bill that would give judges specific rules like guidelines to follow regarding alimony. And in the state we're in today, a ballot initiative is underway in which anti-alimony activists are pushing for a constitutional amendment that would abolish lifetime alimony awards. The concept of alimony today, it's interesting as you read articles about it, we now use two distinct terminologies regarding alimony. One is considered traditional alimony, meaning that's the old concept that many of us grew up with, versus rehabilitative alimony. One of the major